The very fact that Mr. Gicheru now keeps quiet, there are two things that can come out of this trial. And I want to be candid and tell you it is very difficult. First, I want to tell you that it is very difficult to defeat Article 70. They only need probative value, what we call probative value of the evidence. Were you near? Did you talk to one of them? Is there proof that money was transferred? Where did the money come from? If you didn't have that money on account, did you talk to that person? A mere proof that that was the case is not beyond reasonable doubt on Article 70. The other articles, you need reasonable doubt. Did you kill? But I'm telling you, from what you can see, the case of Bemba versus the chief prosecutor and the witnesses, the lawyer of Bemba used to go and look for witnesses, talk to them, until some of the witnesses recorded him and came back and told them, he has threatened us, he talked to us, he sent us money. And the amount of money in Bemba's case were about $200, $300. It's not the amount of money that we are talking about in the Gicheru case. So, all in all, Article 70, tampering of witnesses, is a very serious crime against the court. It's not the state against you. It is the court against an individual. And that individual in this instance is Paul Gicheru. He is there. He should have come out with his defense and said, I don't know these people. The very fact that he has said he is not going to give any evidence is an assumption that he is guilty already. Therefore, the judge doesn't need to look anywhere else. Even if the lawyer talks, because they will know the lawyer has to mitigate, even at times lie, just as Karim was lying, that there was no evidence interfered with. Karim himself, the chief prosecutor, is a liar, because at that time he lied. It is, if this case is proved, Miriam, it is now going to be Karim to say, did you know this or you did not know this? What could come out in May? I hope so. Candid to Kenyans, that this case could be, after it has been summarized in next week, the court will go back to keep quiet, study the evidence. By the end of the month, next month, there will be determination. The determination will change the course of the politics and the course of the journey that we have been talking about. Because the lawyers of Mr. Gicheru did not manage to shrug themselves off from the evidence of William Ruto. William Ruto's evidence was brought and actually here tested fresh. So you can't say I'm not part of this trial. Whoever is advising William Ruto that he's not part of the trial, in fact, if your evidence which was against you is part of the trial, then you're already part of the trial. So he's also equally on trial. Another point that I would want the audience and other people worldwide who don't know more about ICC is the question of, you have been mentioned 800 times in court. The judge would like to know who you are. Who is this big man they call big man? If the case comes to a conclusion, the judge could recommend that those who are mentioned as accomplices must appear, must also be, action should be taken in the final determination. Therefore, the prosecution could decide that since, and go back to Chamber 2 and ask for more warrants of arrest. unsealed or sealed, whatever you call them, they will come. That's the possibility that there are more people out there who took part in a scheme together with William, with Paul Gigeru. So this case then now sealed or bonded that. You can't say I was not there. You cannot be a managing director of a company where money is being drawn and you are the owner of the company, and then say you didn't know that money was being drawn. Then what was your managing director telling you that the money went where? Another strand is the records of telephone conversation voices. The ICC has picked Safaricom discussions. It has taken them between Gigeru and William Ruto and others. So the judge will listen to these telephone conversations. What were they talking about? Above all, I don't think Gigeru was talking encouraging, because Gigeru was talking either in Swahili or was talking in English. Because most of the people accused with Gigeru, none of them talks the language that Gigeru would understand. Therefore, we have a problem there. If those records prove that, yes, Ruto was making communication with Mr. Gigeru in the direction that they should go and tamper with the witnesses under Article 70, that is a sealed case. It is not dead end, it is an open end. The prosecution could decide that now that we have got Mr. Gigeru, can we now also bring Mr. Ruto? Do we open Ruto's case because of Mr. Gigeru? It depends on the evidence, on how far that evidence is going to affect and implicate, and who were the key witnesses who have come out under the Gigeru trial, who could actually be very beneficial to the new evidence. Remember, the 7 witnesses are the ones who recanted, and therefore the trial of Ruto could not take off because they had recanted, Miriam. And therefore, when you look at that, that presents another dilemma.